Mombasa County.
Nakuru Surgeon Dr. Magare Gikenyi, Busia Senator Okiya Omtata, and two other petitioners have moved to court, challenging the creation of the position of Chief Administrative Secretaries and two other positions under the newly enacted laws. The petitioners who filed the case at the Nakuru Law Courts also challenged the creation of the position of the Chief of Staff and Head of Public Service, terming the new law unconstitutional. The National Assembly passed the National Government Administration Amendment Act 2024 earlier this month, with the changes coming into effect on May 17th. Ken Gashuhi reports.
For yet another time, creation and appointment of officers to the positions of Chief Administrative Secretaries and the Chief of Staff and Head of Public Service is in limbo after four activists moved to court and filed a petition against the establishment or appointments to the offices. Dr. Magare Gikenyi, Busia Senator Okiya Omtata, and human rights activists Karanja Matindi and Blair Angima have filed the petition at the Nakuru Law Courts.
Position of the CAS, what they call Chief Administrative Secretary, who call themselves deputy cabinet secretaries. In addition, there's also a position called head of civil service, chief of staff and head of civil service. If you see these two positions, they are not constitutional.
The CAS positions and that of the Chief of Staff and Head of Public Service, currently held by Felix Koskei, were created recently when the National Government Administration Amendment Act of 2024 came to effect on May 17, 2024. The petitioners now faulting Parliament for passing the new law.
The Kenyan people, in their own wisdom, made an executive to contain the president, the deputy president, the cabinet secretaries, and the permanent secretaries. But by creating this position of the head of civil service and also the issue of CAS, the executive and the parliament are trying to take away the sovereignty of the Kenyan people.
They argue that the creation of the offices whose holders shall be deemed as state officers can only be done through a constitutional amendment, as they interfere with the structure of the executive and not by amending a select laws.
If you want to have those CSs, they have to be part of. They need to do a constitutional amendment to make them state officers as provided in Article 260 of the Constitution. We used to have assistant ministers, but in the wisdom of Kenyan during the 2010 Constitution, they did away with them. But now the executive is doing through what I can call the back door to introduce the assistant minister.
And with the prevailing tough economic conditions, the petitioners argue that the creation of the offices is a duplication of roles within the respective ministries and a move aimed at rewarding political cronies whose roles will not directly benefit Kenyans, but instead overburden them. The CAS positions expected to expand the wage bill by 450 million shillings annually.
Any positions which are created should serve the mwananchi, the common mwananchi, not the so-called politicians. We are overtaxed. At the same time, after being overtaxed, we are now, that money is being used to pay some 2, 3, or some 50, 100 CSs. 450 million in a year, it's a lot of money. It can build a lot of schools, it can build a lot of hospitals, it can assist the poor people, it can assist job creation.
The four now want the court to certify the matter as urgent and to suspend any further implementation of the Amendment Act, pending hearing and determination of the case. Ken Gashuhi, KTN News.
The Ethics and Anti-Corruption Commission has